that we are going to take this matter to the court of the people.
Since last week, on several occasions, National Unity Platform Principal Robert Kyagulanyi Ssentamu has been insinuating on plans to withdraw the 1st February presidential petition from the Supreme Court. Monday, 22nd February 2021, has seen Robert Kyagulanyi rubber stamp his long-day dream into reality.
For the reasons that we've given above, we have decided to withdraw from their court.
As per the provisions of the Presidential Elections Act as amended in 2005, Article 6.1, Clause 1, an election petition shall not be withdrawn except with leave of court and after such notice has been given as court may direct.
When the law says that you seek leave of court, that means you have to make an application. And as you make an application, you give the grounds as to why you are withdrawing your matter from court. Why it is with leave, it's because there are some conditions that may be put. There are some conditions that may be put. Because the fact that one may have filed the petition in court and served it on the other party goes out of the way to prepare, to instruct lawyers, to run around, to do ABCD. And in all, that is something that is time-consuming, and it is something that can be a cost. So now, when you apply to withdraw such a petition, the court has to listen to your grounds, and it has to see whether, yes, you are withdrawing, but what are the grounds? The grounds will inform court on what conditions that it may set for you as you withdraw your matter.
Although the law okays the withdrawal, the Judiciary spokesperson Kyagulanyi asserts that court must be served formally.
We have therefore instructed our lawyers to withdraw the case from Mr. Owinyidoro's court.
We have also been learning from the press, because there is no application as we speak now about the withdrawal of the petition which has been filed.
Kyagulanyi, among others, digs out the recent decision by the Supreme Court to disallow his amendments, affidavits, and failure for recusal of some members of the bench, thus anchoring his attempts to withdraw the case.
I want to remind you that the same court rejected with us what it accepted with other petitioners. So that is clearly bias.
You see, when you say the judiciary is not independent, when you are the same person who received a ruling just a few days ago, which you are using as a ground that you had been curtailed, and court had to intervene and grant you an order. The same court granted you the order. These are the courts of law. So you can't say the courts of law have lost independence when they have given you a ruling a few days ago in your favor.
As to where this leaves the face and credibility of the country's judiciary, which has come a long way, this is a question I put to Kyagulanyi, the judicial spokesperson.
We have to continue set with our program as court until we receive formal communication about whatever the intentions are. Otherwise, the court sitting on Wednesday is still standing until we are notified otherwise.
The cost implications by the petitioner as he pleads for withdrawal of his case now remains the one stumbling block to Robert Kyagulanyi. As to whether he will comply, time will tell. Robert